Okay, welcome back. There were some questions about some of the CLE forms. So just to kind of touch on some of the housekeeping again. First of all of the program materials will be on the web page of the Ag Law Center. The PowerPoint presentations for today, if they're not already posted, they will be posted shortly. And the CLE forms, we have a separate form for each day. So there's a CLE form for today. There's a second CLE form for Thursday. And so you could submit each of those forms at the end of the day. So you can submit today's CLE form at the end of today, Thursday's CLE form at the end of Thursday. This is a screenshot of our website, and you can see one of the pictures in the slide deck on the banner is of the symposium. You can click on that, and that will take you to all of the program material. Okay, so Tom and Dan gave us a great overview. Just to kind of put that session in the context of the overall program. The second session, as well as the third session today, are focusing on landowner and leasing issues. And then on Thursday, we'll start off on Thursday with two representatives from solar companies that will talk about their perspective and as they work through the process. And then the second hour on Thursday that Dan referenced will be Professor Bodisi and Tom and Dan talking about municipal issues and community engagement. And then we'll conclude Thursday with a discussion of some incentive and some other kind of big picture items. So our second session is the anatomy of a utility scale solar leasing relationship. And our presenters for this second session, we have Dan Brockett again, the extension educator with Penn State Extension, and we have Brook Duer. Brook is a staff attorney with the Center for Ag and Shale Law, and Brook has a wealth of experience as an attorney in private practice and then with the Pennsylvania Department of Agriculture. So he brings that government experience, that private practice experience to his role as a staff attorney here with the Ag Law Center. So we'll start off with the code word again, and you can see the code word on your screen is leasing. So those of you applying for CLE credits, you'll need to put this word leasing on your CLE form under session 2. And with that, I will turn it over to Brook to talk about the anatomy of a utility scale solar leasing relationship.
All right, before we let Brook talk here, I had a question at the end of last session, and just one, this is an inadequate answer, but there are actually 8 solar projects in Pennsylvania that are in service. Here they are, okay, listed 1 through 8. There are no more at this moment. So if you are familiar with those projects in those communities, that's what we got. Brook, I'm going to stop and you can take it away.
Okay. All right. Let me get my screen sharing properly here. First of all, hopefully, can somebody give me a thumbs up or we're looking good?
It looks good, Brook. We can see your screen.
Okay. So we're going to talk about the anatomy of a solar leasing relationship, a utility scale solar leasing relationship. And the reason that we're calling it that is because we're going to talk about some general principles about the relationship first. And then later in the next hour after this, we'll talk more specifically about terms of these leases. So we'll sort of divide this up into 2 parts, mostly because I think there's a little bit of background that is very helpful to understand about what kind of a business relationship you're getting into if you are considering executing a lease and getting into this from a landowner's perspective. Most of the material, and we've done a bunch of these webinars, has been landowner education centric. That's what we've been basically doing. trying to prepare landowners for what it is that they're being handed out there, in a field by a landman of some kind. And so that's where we're going to be coming from. And some of this may be a little below the level of some of our attorneys who are in attendance here and getting CLEs. Some of it may be a little bit above the level of some of our non-attorneys. Hopefully we hit the sweet spot where we're covering both interest groups here and both sets of attendees, and we're not losing anybody or boring anyone. Now, first, why am I not getting a advancement here? There we go. Okay, so we're dividing the time between myself and Dan Brockett will be here sort of riding shotgun with me and hopefully making sure I don't screw anything up. Both of us will field questions in terms of the Q&A later. And yeah, please do load us up with questions in the Q&A function so that we can have a nice lively session. Nothing worse than doing one of these events and not having questions. So please load us up here, and that would just be wonderful. Okay, now, why is this industry leasing versus purchasing? You probably can sort of intuitively figure out the answer to that question just by what it is that you've heard so far. There are so many variables in these projects that and few of those are under their actual control. You have, municipal government issues, you have the PJM interconnect, you have physical layout, how do you connect to the transmission lines, where are they located? One of the things that you'll learn very quickly about these projects is that it's generally a series, or many projects anyway, involve a number of separate properties, maybe 70 acres here, 50 acres over there, 125 acres over there. And the economy of scale that then becomes achieved by having multiple properties all then essentially selling to the grid in one unified transmission, so to speak, is a lot cheaper than just doing it one at a time. So a lot of this heavy investment that has to go on, you want to spread it out over multiple properties, multiple aggregation of acreage, so that you're making it economically viable. So that's there's a lot of that makes this very high on the variables. Now, if all you were doing was generating electricity through photovoltaic cells, hey, that'd be great. I mean, it's expensive, very expensive, as you heard, but that is probably the simplest part of it all. Very capital intensive. You heard those numbers. Just keep that in mind again. $1.13 million per megawatt. And then the megawatts were 6 was the number that Dan was using there. There's some DEP publications from a while back that used 8. So you're in that ballpark. And we'll probably hear from people later who know better than I do exactly what numbers should be used. And you heard Dan's using 6. And so you can already see that 60 acres, is that like $10 million? I mean, you can start doing some of this math in your head and realize how capital intensive this really is to be. And then you think back to what you saw from Tom in the sort of the virtual tour there, and the number of acres just in that one piece of Penn State's project that's being built by Lightsource BP. And then you can start to understand how capital intensive this is. But again, that's probably the simplest part, because after that, then you get to these variables about how do you get the electricity to the grid. You have to deal with highways. You got to deal with water courses. You got to deal with railroad tracks. You've got to deal with all kinds of impediments to get from whatever property seems to be looking attractive, or whatever set of properties, and that's really where it starts the complications multiply, the set of properties, and then getting the electricity to the grid. So the variables just start to exponentially multiply when you understand how these projects go. And then of course you add in making it all economically viable. It just becomes a Rubik cube that that's why we have this situation where it's really sort of a game of numbers. A lot of possible projects are being investigated at any given time by a solar developer who's getting into this industry, but very few of them are going to get built. But you have to do it. It's a game of numbers. You have to have that many irons in the fire in order to get a few that possibly are going to be economically viable. And Professor Boddisy from Dickinson is going to talk a little bit about some of those economic forces and what makes a project viable. Soft costs and the hard costs, and there's just a lot to juggle there. And so it sounds a little bit like in its barest form, it sounds a little bit like a sort of a Wild West kind of speculative industry where you're really hedging your bets. Got 10 projects going and maybe you'll finally build one. That's the nature of the industry. So that's some businesses just need to operate that way. You got to get into it. You got to sign up the properties. Then you have the right as a developer to look into all of the things that involve that particular property carries with it in terms of the hurdles to get to the grid from there. And then you figure you just have to weed out what's working and what isn't working. And you got to have the standing. You got to have the contractual authority to go ahead to investigate all these different projects. And of course, some of that involves municipal approvals, which we're going to see in the coming years. Okay, so option to lease seems to fit the bill. That seems to be the instrument that is fitting this industry at this time. Does not mean that outright purchase won't fit the industry's needs at some time in the future. Might not mean that a lot of the options to lease and then leases that get signed and maybe they go forward. And then maybe the whole thing turns into a purchase sometime later when you're in the middle of the lease term itself. So this is an evolving industry. Now,
Brooke, if I could
caveats-
insert on
Yes.
that, because I mentioned some numbers on leasing, I hesitate to share purchase option numbers, but the very few that we have seen tend to be 2 to 3 times fair market value in that community. So they are hard for landowners to maybe resist, but they certainly clear up a lot of issues that you might deal with in a lease document.
Yeah, and because as an attorney, after Dan and Tom drafted me into assisting them with some of the leasing mechanics of this public education effort that we've been doing, and after a few months of being in it, I sort of looked and said, well, boy, this leasing thing is complicated. Why isn't it just an outright purchase? That would be so much simpler. But that would have to be a very guaranteed location. You can get to the grid there. You're going to get the municipal approval because you have an ordinance that actually has parameters and something that you can refer to and has predictability. We don't have that right now. We have so few ordinances that give anybody predictability. You buying a property on the idea that you're going to get the local zoning approval to do this on it is a very dicey prospect right now, unless you really have a unique municipality. Okay, caveats. Things move rapidly in this fledgling industry, and they're going to continue to do so in the next couple of years. I am presenting from a standpoint of what is sort of a generic example of a grid scale solar leasing relationship. But every circumstance, every solar developer they have unique ways of doing things, unique terms that they use, unique agreements that they use. They have a certain approach, and things that I say here are more of a generic example. I have a stack of agreements, lease agreements that were tendered, generally with the parties, redacted, but those are old. And 6 months in this industry, particularly with the advent of the pandemic, we had this little bit of a dip where agreements have changed in 6 months, 8 months, 9 months, 12 months. People are getting a little more sophisticated with the agreements, but there are still issues, and Dan mentioned a few of them. Okay, basically 2 parts to every deal that gets proposed to a landowner. The first is the option agreement. The second is the lease agreement. Option agreement is essentially an option to lease. Mr. Landowner, here's what I will pay you in order to have the exclusive right to lease your X number of acres for the building of a solar generating facility. And usually the option agreements might be 10, 15, 20 pages long, but attached to them is the lease itself. And I've even seen now, and this is one of these things that has changed quickly, you now see them combined into one document, whereas you always used to see them as two separate documents. I'm still going to talk about them for the most part like they're two separate documents, but you do see them combined now in some instances. Anyway, the lease document itself is the whopper. That's the big one, might be 40, 60, 80 pages, who knows? It's always attached to the option agreement. And the idea being, as you know, the attorneys in the crowd know, which is the option agreement says, I, Mr. Landowner, like to have the exclusive right to lease your property through the attached lease. So there's your lease terms already being presented to you at the time that the option agreement is being presented. And there is no turning back when you sign that thing, because those lease terms, you are essentially, and I don't want to overstate it because I'm sure that there are instances where things happen that perhaps something can get revisited later, but you're basically agreeing to this huge lease agreement that could have a 20, 30, 40, 50-year term when you sign the option agreement. And the reason that, you know, and the thing that is a bit jarring when you look at these is that when the option to lease is exercised, generally the landowner is given a matter of days to get the signature back on the lease agreement itself. There's no more negotiations. You had to have negotiated this stuff up front when you signed the option agreement. And this is again, keep in mind, this is a unilateral option. So only the developer has the right after the option agreement is signed to say, oh, didn't pan out on my end, not interested, thank you very much. You know, we paid you our option payments in order to tie the property up, and we've decided that we're not interested, thank you very much. And the company or the parties part ways. The landowner does not have that ability. There is no walking away from the deal for the landowner once the option agreement is signed. They sit and wait to see if the lease option will be picked up. And they can't say no if it is picked up. Otherwise, you've got some sort of a breach of contract problem on your hand. So that's important to understand. And again, I give this landowner or this educational sort of webinar a talk to many landowners directly. And they need, you know, I like to drill that in to make sure they get that. Now, sometimes there's another little document. It's like a little letter of intent. And it just might be a couple of terms on a single page or 2 pages or something like that. And the point with that is that they want to, the solar developer wants to tie up your confidentiality obligations. In other words, they'll give you a letter of intent saying, well, we're looking into this property. Here's the kind of ballpark we're talking about. Just let you know, and please sign this, acknowledging that you received this. You know, nothing's binding, et cetera, except they want you to, there's a confidentiality clause in there. So the idea is that, you know, there's a bit of overlay to all of these negotiations that you have to understand. As we talked about, multiple properties are generally grouped together to get the power to the grid in the most economical way. They don't want you going around talking to all the other neighbors that they're also talking to and trading notes and trading amounts. And what did they offer you and what did they offer you? Well, we all know how that goes. You know, there's confidentiality clauses and then there's reality. But the bottom line is that's what those little letters of intent are for. That's really the whole point of them. So sometimes you'll see that involved also. Don't know if that's as common as it was before, but okay. Now, big picture again, I'm just staying way up here at the 40,000 foot view. Here's the timeline of essentially the lease negotiation and you know, term. Number one, you have your option effective date, which is when the signature on the option agreement happens. And at that point, there is some monetary obligation to pay the option payments in whatever form they may be, annual, generally annual, not monthly. And generally these option agreements are for a couple years. We'll talk about that in a second. Then there's the option phase, which is essentially just a big due diligence period where now the developer has access to the property through the option agreement, can go out and come to the site, do whatever investigations it needs of the physical site, go to the courthouse, do all of the title searches, do everything that's necessary in order to figure out all of the aspects of this property and whether this is a viable site for them to proceed. Then, if the option is exercised after this due diligence is performed, and again, that could be a couple years worth of investigation going on, where they're juggling not only maybe 3 properties that are involved with your property to get to the grid, but then maybe half a county away, they're also working on another one. And so there's multiple things being juggled during these due diligence periods simultaneously. They might have 20 things they're looking at that are all dependent on 20 other things. So anyway, once you get the lease or the option to lease exercised, the option is exercised, then you have the lease effective date, and then that's when payments in earnest begin. And generally, that's on some type of a monthly basis, it could be on annual basis. And first you have the construction phase. Now, the payments during the construction phase are usually a little bit different than during the operational phase when electricity is being generated. Then you have your operational phase, which is when you're actually generating electricity for the grid. That's the full rent value. That's the most rent you're ever going to earn. And then there may be renewals in there. It might be 10 years, a series of 10 years, or it might be 25 years with, a 15-year, and so, it could be any number of commitments of that nature, but you can already hear they're very long. There's no such thing as a 5-year and then maybe a two more 5 years, and that's it. And that's because these things cost tens of millions of dollars and they have to pay for themselves. So these are big long-term agreements. And we'll talk about how that plays out later. Now, the last thing is, theoretically, someday it comes to an end. We've not seen one yet come to an end, but someday one will. And theoretically, there's to be this decommissioning phase when all the structures that have been put on the surface are removed. Now, you got to make sure you negotiate to have some money paid during the decommissioning phase. That's what keeps their feet to the fire to make sure they finish up. Then you have your termination date. Now, I think there's a lot of speculation in the world at this point as to whether anything will ever be decommissioned. I think I've learned over time that the gold in these transactions is once you are hooked up to the grid, that's where the value is. And I don't think it's very reasonable to assume that people are going to abandon that value. That has value, whether the company that is in the midst of trying to operate it now goes belly up for some reason, someone else is going to be interested. And so I think this is more along the lines of something that is going to be bought and sold and multiple times over the course of any term, and it's going to last longer than whatever the original written agreements were, unless another power source comes along like hydrogen that displaces solar, because this is always going to have value once a connection to the internet is established, or to the grid is established. And I don't think this fear that there's going to be these abandoned fields of solar panels out there. I don't know how realistic that really is in the grand scheme of things. Now, the option agreement, again, we talked about that. Usually it may be as long as 5 years. You have the more or less the due diligence period. We've sort of talked about that. Title reports and everything else are obtained. Used to be some of the agreements that we would see were very heavy on the landowner, disclosures, et cetera. That's why you guys are the developer, and you get paid the big bucks because you can do your due diligence on your own. Rarely do you have something that the landowner is going to tell them or show them that is news to the developer once they've started their process. In any event, I think we've pretty much covered all that. Now, the lease agreement, of course, once it's exercised, then again, it's usually a period of days until the signature on the lease has to be delivered. We've also seen them now where they want the lease signed up front at the same time as the option, or they're combined into one document where you're committed to the lease very specifically. It's clear that you've signed the entire thing at the outset. So I think maybe this idea of the staggered signatures may end up going away. But again, the lesson out of this is there's no time to renegotiate. So the landowner is, generally not a sophisticated commercial party who's used to being involved in something this complex, and yet they're being given the hardest job up front in terms of having this entire relationship that could last 40 years or whatever it may be, essentially negotiated in a manner that's acceptable to them, all on the front end. And then you have to understand, of course, that this thing will be recorded, and it will be in the chain of title of this real estate past that person's lifetime, in most instances, in any event, and it's going to run with the land, and all successor owners are going to have to deal with all the same contractual obligations that this initial person that signed the option agreed to. So this is a serious undertaking. And that's why we talked before. Dan mentioned the idea of somehow doing this on your own with no attorney is just not realistic. These agreements, and we'll talk about that in a minute, are just not. They're not battle tested. They're not something you can trust to be generally okay and written in some even-handed way. They are not. And they are sloppy at times, no offense to any solar developers out there, but there are big chunks of things sometimes that are missing that just, why wouldn't you have this in there? Or why do you have this in there? It's completely unrealistic. So because these just are not battle-tested documents. What you're signing when you sign this lease agreement is what the attorneys in the crowd know of as a ground lease. It's just the old-fashioned ground lease, which is not really necessarily a favorite instrument for doing business, and there's many reasons for that. We'll talk about that in a minute. I don't know if I said this in here, but they remind me, when you look at some of these documents for the attorneys here, that reminds me of it's like a shopping center development or an office park development lease, where you have a ground lease, and then you have someone who's going to build something like an office park on top, or an industrial park on top, or that's the kind of documents from which these things have been adapted, and therefore you can already see that 70 pages is pretty easy to chew through when you're dealing with documents of that nature. Now, I will say there are some of the companies have been getting better. We've been seeing more streamlined, more realistic documents. But just understand, they all came from the commercial real estate world. Some high rise in Manhattan, and somebody hit a button on the computer and they spit out this form that's been adapted from some office park lease that they used 300 times to build office parks, and they're not, they have been adapted, but not adapted in a way that you can trust. I'll just put it that way. Okay, now here's the most important thing about understanding this sophisticated relationship that your client or you are getting into, which is any entity or party out there that has a competing legal interest of any kind in this property, such as the holder of a mortgage on the property, is going to be significantly impacted by this, because the solar tenant is building structures that cost tens of millions of dollars on land that they don't even own. That is not a business relationship for the faint of heart. That is not a business relationship that most of us are all that used to, and certainly not landowners who aren't generally conversant in the kind of things that type of relationship would require as protection for those tens of millions of dollars of investment that has just been made on, in someone else's property. So, that just is a real precarious position for these developers to be in. That is, let's lay that groundwork, and now let's go on and talk about this idea of competing legal interests. So what does that groundwork mean? It means that anyone that has the ability to disturb their continued generation of electricity on that site for the 40 years of that lease is a problem for them, and has to be dealt with. So what's the first issue? Well, for mortgages, you're going to have all mortgages subordinated to this lease. They can't afford to have somebody foreclosing on a mortgage, whether it's the current owner who says, "Oh, of course, I always pay my bills." What about the second or third owner who owns this property 35 years from now, perhaps? So mortgages, it's a given. They have to be subordinated to this lease, so that this lease is always, or so that the solar developer always has the superior right to continue to generate electricity and derive the income from what they've invested, so that they can pay it off, and they can't have that income stream interrupted by anything else going on. Same thing with any other kind of lien that can be foreclosed upon, a judgment lien or any other type of lien. Or if there's maybe other leases of some kind out there, they all have to be subordinated to this lien, this lease. This lease and this tenant needs to be superior to everything that could interrupt their ability to continue to generate electricity. Also got to look at rights of way and easements that might have been granted. Anything that's in the chain of title that has the ability to somehow disrupt the generation of electricity is going to be looked at during the due diligence period, and could scuttle the deal, or it's going to have to be provided for by some type of amendatory document or curative documents or whatever it may take. Also, competing legal interests can be in the form of various governmental programs, like let's say you've invested you've enrolled your property in the Clean and Green Preferential Tax Assessment Program. That's one where a change of use, Clean and Green in Pennsylvania does not permit the commercial generation, grid scale generation of electrical energy or electricity. So Clean and Green, essentially, they're going to boot you out of the program if, in fact, you commence construction for a project. Now, so that's another competing legal interest that you got to see is going to be impacted. Not that they can disrupt the generation of electricity in that case, but it can cost the landowner a lot of money. Being kicked out of the Clean and Green program involves rollback taxes of 7 years of the last 7 years of tax savings. Sometimes the solar developer might agree to pay that. It might be the cost of doing business to them if it's attractive enough property for them. Also, if the property is enrolled in any kind of Farm Services Agency or NRCS administered program where there are certain conservation practices that are required, that's going to be a problem. And an agricultural conservation easement that's been purchased under Pennsylvania's state law, this is an impermissible use on any property subject to an ag conservation easement under Pennsylvania law. For private conservation easements, you got to refer to the terms of the easement to see whether it violates it or not. But those are all the competing legal interests that can cause problems and make either a project unattractive and undoable, or it may require some type of specific amendments or some type of action to be taken. So landowners got to know all those things, sort of going in, exactly what is going to make this project work and what might kill the project. Now, let me see. I'm going to go ahead. Let's see what kind of time we got. Okay. In terms of competing legal interests, other things that can cause impacts here. How about a hunting lease? Maybe you have Tom used the 175-acre property down there in Franklin County. Okay, let's say that the owner, actually owns 300 acres, and that's 175 of which on the other 125, it's got some wooded area and he's got a hunting lease. Well, the solar developer is not going to be wanting stray rounds bouncing off his solar panels. So that's, that can be a problem. Sometimes you may just have to bite the bullet, and or I should say you, the landowner, but the developer may decide that, well, we're going to buy people out of existing leases just to get this out of the way and make sure that it doesn't disturb our ability to generate electricity without problems. Subsurface rights. There you go. We've all lived through, what subsurface right owners can do with accessing the surface and causing disturbances of whatever activity may have been going on the surface. Same thing here. A solar developer cannot afford to have someone who owns subsurface rights exercising their rights to disturb the surface right in the middle of their solar panel field. So that's going to be a big problem that could be insurmountable. Existing easements, we talked about that a little bit. We talked about enrollment in government programs. Okay, so that's a principle that you got to keep in mind. These are competing legal interests with this tenant who now wants to be superior to anything, to the extent that any other rights in the property could disturb their ability to generate electricity and generate the income they need to pay for these panels. And of course, those panels are offered as collateral on their financing, which we'll get to in a minute. I think we talked about everything that's on this slide. I'm going to go ahead and, okay. This is why I'm sort of calling this seminar, or this section, or this session, more of a discussion of the relationship that's being created, because we're not going to get into specific terms so much as we're talking up here about the relationship. So I like to explain this to landowners in a way that sort of breaks it down. There's 4 basic principles to understand. They all have their little pieces, but if you understand these, then you have a much better understanding of what is this deal, what is motivating the tenant you're about to bring in, who wants to lease your land, and why some of these terms that they are insisting upon, exist. This is a level of sophistication in terms of a transaction that most landowners have never seen. This is not leasing some acreage for somebody to farm. This is a commitment that's going to last past your lifetime or past the landowner's lifetime, and it's going to have significant consequences. Okay, first of all, talked about this before. This is an industry in its infancy. None of these documents are battle tested. We talked about that. These are all new documents. That can be good, that can be bad. Landowners should never sign any of these forms as is. I have seen so many glaring problems that if you were looking at documents that had been used for decades, wouldn't exist any longer. But they exist in these documents because people just have not encountered them enough and have not worn away the problems, and the rough edges haven't been worn down. They still have things that are inappropriate and don't fit a landowner's situation. So you have to watch them very closely. There's just no substitute for that. The good thing, that's the bad thing about these documents being not battle tested. The good thing is there's probably a lot fewer things that are off limits for negotiation. The deal breakers, so to speak, haven't really been established yet, except in a couple of areas, which I'll try to highlight as we go forward. Now, again, landowners will never be able to negotiate these contract details themselves, and they're going to have an attorney. And, that is just, and so for all attorneys in the audience here, this is a market that needs you. These people need attorneys, and, it's a scary prospect when you think of somebody, a rural landowner who's maybe, got a family property of 300 acres, some wooded, maybe some is leased out to farm, maybe they've, generation farmed it, whatever the situation may be. These clients, how this works, and what level they need to have things, walk through. And to think of them on their own in this circumstance is just very troubling. Few attorneys have worked with these exact forms, but I always say that's okay because they're actually not that overly complex from an attorney's perspective. Anybody who has negotiated a commercial lease is going to know the basic principles. You're going to see, as soon as you look at this thing, you see what it is and where it came from. Now, I do say when I give this presentation, it's like a commercial lease on steroids. Why is it on steroids? Well, that's because it's such a long, term, number one, and tens of millions of dollars are being invested, by this tenant in building structures that's on property that they don't even own. It's precarious. Now, this is really, and I like to say it enough that hopefully it sinks in, this is transforming a general rural landowner into a commercial landlord. And there's a level of sophistication that they're going to have to start to understand and adopt to some degree. Otherwise, there's going to be problems. And it's a level of sophistication here that they've probably, again, I said it before, they probably never dealt with. Again, it's 50 years long, some of them. And again, point that I, repeated, which is you're building tens of $1 million structures or structures costing tens of millions of dollars on somebody else's property, and they want protection. And there's another about the most novel thing really in these agreements, besides the sheer sort of weight of them, is that there's this thing called a solar easement, which is an interesting concept, which is that essentially, if you had this scenario we're using before, 175 acres are leased of a family property that's got 300 acres. That other 125 acres is subject to a solar easement. You can't block the sun to that 175 that's being leased. So they have an existing solar easement over the other, the surrounding acreage to make sure that there's nothing that goes up that's going to block the sunlight, and that it's basically 24/7, direct sun access at all times. Nothing that can be done on, nothing that is done on the surrounding acreage can ever block that. That's about the most unique principle, honestly, that is involved in this. Okay, now let's see if that what. Okay,
Brook, you're at a break. I'm
yeah.
just going to interject here.
Okay.
I am going to launch a poll. So if for the audience, if you could just respond to the poll. I forgot to mention that at the beginning of the hour.
Okay. All right. So then just vote on the poll, and it'll go off your screen, I believe, as soon as you vote on it. There we go. All right. Now, I think I covered what's on this screen here. Now, keep in mind, and this is when we're going to, now let's get to this collateral idea. So not only do they not, they cannot, the tenant cannot tolerate having the income stream, i.e. the sale of electricity, interrupted. They also got a creditor, their lender, whoever that may be, who put up the tens of millions of dollars. These structures that are built on the property are pledged as collateral for that tens of millions of dollars of financing. So now you have another party involved, the creditor of your tenant, who's got an interest in this thing. And so again, you can see that the complexity, starting to build, that your average rural landowner is not going to be quite able to comprehend right away without some, significant explanation. Again, everything's got to be subordinated to this lease because of the need to protect the collateral and keep the income coming in. Now, other part of this that is, to keep in mind, another layer here, which is the tenant, the solar developer, always has the ability to assign the lease without landowner approval. So into these things, we don't know how it's going to shake out as this industry matures, but into these things a few years, let's say you're in 10, 15 years, you're probably going to be on your second or third party in terms of who is the actual tenant generating the electricity in there. And that's going to change hands without any, right to, or without any approval rights on your side as the landowner. That's something you got to understand and be ready for as a landowner. And then you can see the level of sophistication to be able to deal with that type of circumstance. There are people that are in this industry that may very well be doing it simply to build out a portfolio and then flip it, so to speak. And I don't like to use that word to describe, it's generally looked at as a derogatory term, but it's simply the nature of an industry like this. There's going to be bigger fish that are going to come along, and these portfolios of either leases or producing sites are going to get flipped. There's no question about it, and probably multiple times. Now, the long-term business relationship part of this is also a whole nother thing. Not only will you have these several tenant, identity changes, but you're also going to have changes in the land ownership on the landowner's side. Yes, there'll be that, occasion when, heirs of the original person that signed the lease will still be the owners, but that may be not the, who knows, what percentage 40 years from now will be heirs of the original signer or signers, and will be simply people that purchased the property subject to this lease and purchased it as is with the lease in existence, and they're going to have to live with that as the attributes of this property. Now, property tax obligations. The agreements have been pretty explicit that this industry understands it's their obligation to pay the increase in property taxes, of course, that are attributable to the structures that are built on the property. We're not real, we don't have a lot of good intelligence and data on exactly how the tax assessors of our state are going to be treating, reassessments and the increased assessments from these structures. But we do know one thing: this landowner now is going to have to split the bill with whoever is their tenant generating the electricity every single year. So that's a piece of business that has to be attended to every single year, and has to be done in a way that that works and is workable. And I have some other things to say about that in the next session. Okay. The tenant needs to make
Brooke,
sure.
if I could just interject one more. We still have a few more people that haven't voted on the poll. I'll just give about another 30 seconds or so, and then we'll close that poll. So if you haven't voted, please do so. And I guess it closed for me automatically here. So Brooke, we're about at the 12-minute mark. We have a few questions. So
all right,
just to kind of give you a heads up on that.
All right. And I can probably, a lot of the things that I would normally say, and that's my last slide here. I have a few other things, but we can probably, I'll talk about one more aspect of this, or two more aspects. The liability insurance was already mentioned in the question, which is the general outline, and the industry, of course, understands that it's their responsibility as a solar developer to purchase adequate liability insurance that covers the landowner for any and all potential liabilities relating to the developer's activities on the site. It's not anything that needs to be negotiated. Everyone understands that. There's some little twists and turns there that we'll talk about in the next session. But it's interesting. My experience at the Department of Agriculture, we had solar panels on top of the farm show complex down in Harrisburg. What's the first incident we ever had since those were installed? Wind blew them off the roof. They blew down onto the grounds below the farm show complex. Thankfully, it did not go in any roadways, did not hit anybody, didn't even damage the landscaping, really. But so that was one of my first experiences with solar panels, was finding them laying down on the ground, and having blown off the roof of the farm show complex. Now, that's not to say that that's a danger. I think the technology, that these were not probably affixed as they should have been, which was probably out of respect for the rubber roof more than anything else. Anyway, last thing, decommissioning. Now, there's not a regulatory decommission that's going on here, but people are using that term just to mean this idea that at the end of the lease, these panels need to be removed. Okay, we talked a little bit about that before. How is that really a realistic thing that's going to happen, or are just panels going to be replaced with more efficient ones and more efficient ones? until generating solar electricity has been made economically obsolete by some other form of electrical generation. So that's the decommissioning thing. We'll talk more about that as this entire webinar goes on. Let's go to the question.
Hey, thank you. Can you talk a little bit about question, how flexible is a typical developer in negotiating the terms and conditions of a lease agreement with that property owner? And then is there anything more to that answer if we get, the kind of third party finance folks involved in that?
That's a good question. The first question is, working for Penn State and the Ag Law Center, I'm really on the ag side. I haven't represented clients to negotiate these agreements. I'm sure that we have attorneys here in our audience who have, they may want to, if somebody wants to raise their hand, we could probably even recognize somebody. My experience in talking to attorneys who have been negotiating them is that things are possible. There are a certain number of things that are, as we talked about, deal breakers, but creative thinking can be possible. For example, the whole agrivoltaics thing, where you're doing something underneath the panel, so to speak, that's agriculturally related, that's really just a form of creative thinking, where the landowner, for example, may reserve to themselves certain rights to do certain things. And I think the industry has been open to that. I think the industry likes that connection, and they want to harbor the goodwill that sort of thing can bring. So I think there is flexibility on certain things. Now, inflexibility probably on some other things, like this idea that they can assign the lease without the landowner's approval. Well, they have to have that, period. I mean, they can't be, it can't go any other way. But so hopefully that answers. If somebody wanted to raise their hand, we could certainly listen to them. I think one of the things that we wanted to do by having this seminar or having this symposium, we wanted to generate, a room full of lawyers who are all interested in this work, so that we can maybe take some next steps with that group full of lawyers and maybe create some way of having some sharing of information among lawyers who, want to and are involved in this field. Because again, I am not disturbed as much by anything as I am thinking of a rural landowner, many of whom I've represented, in private practice, trying to deal with this on their own. And we're seeing that out there. It's happening. Okay, Jacob Kiesling from Meddy Evans Woodside raised his hand. Ross, Jackie, do we know how to, somebody know how to acknowledge
I just did, Brooke. We're good. Jacob, do you have any color you can add on that?
Yeah, my experience, and it varies company to company, but you're correct that there's not much that's off limits from a negotiation standpoint, aside from two areas. Their assignment rights are obviously critical to them. Then their third-party financing protections. When I get too involved trying to tie up what's going on there, that's where I'll get a lot of pushback. I generally go through and put kind of form comments that I've come up with that, okay, if my client has to honor the rights or give notice to those third-party financiers, we have to have prior written notice before, that obligation is there, which has to be satisfied before the landowner can pursue its rights in the event of a default. But beyond that, I don't think there's anything that's non-negotiable or shouldn't be brought up. I don't want to throw the kitchen sink at people, but that's my perspective.
I know, Jacob, that reminded me that I did have an exchange with an attorney who was having a problem with the idea of, while the deed was going to remain in like the parent's name, it was going to be a group of children, adult children, who were going to end up being the direct payees of the rent. And there was and in other words, there wasn't this unity of title, or no, I guess that's not the right word for it. wasn't the unity of interest between the name on the deed and who was receiving the rental payments, and that turned into a bit of a mess to try to assign the right to payments to some other party.
On
Because
the
then you're-
landowner assignment, that is a battle that's probably worth having, though, especially with the proposed federal estate tax reduction. The ability for the landowner to assign those payment rights today could become even more of an issue in the next year, because we can get an appraisal of that landlord's interest in the lease, make the assignment now during the option phase, and really save a lot of money before it balloons to some large asset. So
yeah,
that's worth negotiating.
Yep. Anybody else wants to raise their hand?
All right, Brooke, I have a couple more
yes.
questions for you here.
Okay.
So the renewal of these leases, you've seen a few, I've seen a few. The question is, can that lease agreement be renegotiated at the time of renewal? Brooke, I'm tempted to say no. Am I right about that?
No, I think they will be. I think that's going to be a big feature of this industry as it rolls out. You can always, agree to rewrite your deal. And it just means that you're going to have to record the new one, to make sure that it's accurately reflected in the chain of title and that the old one is rescinded. So I do think that's going to happen. I think that while this format that's being tendered to people right now of initial term of X number of years with renewal terms of X and Y and Z, I think that's being done to show that, okay, there's an income stream here that is documented sufficiently to give us the financing to build this. Then once that's in place, I think there will be improvisation on the fly, or whatever word you want to use. I think there will be business decisions made to potentially change the portfolio of your electrical generation, or the developer's electrical generation to match their economic circumstances. Are they able to purchase some of these properties after 10, 15, 20 years because, or do they, other things that may come into play?
Yeah.
And I guess we'll have to see. Right.
For the non-attorneys in the audience, we can't rely on that. But
right.
the reality is it may be renegotiated, but you can't go into the transaction expecting that it will be.
Right.
Yeah, and I guess I was looking at extension clauses, being signed with that very first signature that really spell out what that extension looks like. Anyway, let's move on. Are you saying, you mentioned earlier that the first mortgage would have to subordinate?
Absolutely. I mean, that's
Okay.
absolutely, yes, that is a given. There's no developer that's going to be able to take a position, a lien position, or it with regard to this property that could allow a mortgage that's in front of them to be foreclosed upon, and they get kicked out. They just can't do it. They got tens of millions of dollars on the line here. So yeah.
Dan, I think we're at 2:19, so I would suggest that we just go into our break at this point.
All right, very good.
We can come back. Let's say we'll come back a minute early, so we will reconvene at 2:29, and we're going to continue the discussion of from the landowner's perspective and talk about issues of negotiation.
Thank you.
Thank you, Dan.